Hello everyone and welcome to Module 8, NIL and Contracts. If this video or my recording looks a little bit different, it's because the original recording got corrupted and I'm doing it again at night from my terrazza. Alright, so it looks a little different, I apologize, except I wanted to make sure I had it ready for you by the next morning. So, contracts. What is a contract? The first question is, what is a contract? Think about that. What is a contract? Well, a contract is an agreement between two or more parties. It could be 2, could be 4, could be 20, doesn't matter, but it has to be at least 2. Contract between 2 or more parties that create obligations on both sides that are enforceable or otherwise recognized under the law. Okay, so that's it in a nutshell. Agreement between 2 or more parties, could be 50, 100, that create obligations on all sides that are enforceable or otherwise recognized under the law. A contract, in order to be a valid contract, it has to have all 5 elements. If it's missing an element, it's not a valid contract. Those elements are offer, acceptance, consideration, legality, and capacity. If one of these elements is missing, the contract is not valid and therefore unenforceable. All right, so what is an offer, right? What do we mean by this term offer, this contract term offer? It's basically a promise. It's a conditional promise, though, right? It's a promise to enter into a contract, a willingness to enter into a contract. You intend to enter into a contract. I offer you $5 for that ice cream. You think it's not a contract yet, it's just an offer. I'm offering you $5 for that. All right, so that offer can be revoked, however. All right, that offer can be revoked up until the time that it's been accepted. All right, so you can say to somebody, I'll give you $5 for that ice cream, and before they say I'll accept, you can say, nah, I'm going to spend $6 on this candy over here, or something like that. All right, so it can be revoked at any time up until acceptance, as long as you tell the person who you communicated that offer to. Okay, so that's the first element, offer. The second is acceptance. Right, that person has to accept the offer. Right, you're basically an assent to the terms of that offer. I'm not changing it. I'm not modifying it. I'm not giving a counter offer. I'm saying yes, I'll take what you're giving me, $5 for this ice cream. All right. Only the person who the offer is made can do the acceptance. However, okay, somebody can't step in and say I'll take that offer and it to be enforceable, right? Only the person who that offer is made to can accept the offer themselves. The third element is this concept of consideration, right? This is a little more difficult. All right, consideration is basically an exchange of value. All right, this is the quid pro quo that the state law and the NIL rules for the NCAA mean. There has to be some exchange of value. Both parties have to give up something or do something, all right, in exchange for the other party doing the same. All right? Both sides have to give up something. If there's nothing of value, if I'm giving you $100 and you don't have to do anything, well, that's not consideration. All right, I'm giving you $100 and you have to appear at an autograph signing. Well, that's consideration, right? There has to be an exchange of value. Two things, both parties have to do something or give up something in order for it to be considered consideration. All right, considerational. It's essential to the contract. All right, it's needed. It's one of the most difficult terms to kind of figure out within contract law, but for our purposes, it's basically it creates obligations on both sides. And like I said, this is the quid pro quo. All right. The fourth element is legality. The contract has to be for a legal purpose. If it's for an illegal purpose, it's not valid. Okay, the contract must be for a legal purpose. All right, there are many times people enter contracts that aren't for legal purposes. Gambling, for instance, with an unlicensed professional. And this is kind of, if you read the Zion Williamson thing, right? Unlicensed professional. That agent wasn't licensed in North Carolina. Therefore, the contract wasn't legal. All right, if you hire an agent, that agent needs to be licensed. If you hire an attorney, that attorney needs to be barred and in good standing. If they're not, then that contract between you and the attorney or you and the agent is not legally binding, right? So, other examples are loan sharks, neighborhood distributors. I mean, that's not for a legal purpose, and any of those would not be enforceable under the law. And the last concept is capacity. right? Capacity itself. This means that a person has to have the ability to understand the nature and effects of one's own acts. All right, and basically under contract law, there are two two entities or two people who don't have that requisite capacity, right? Minors, if you're under the age of 18, by law, you don't have the requisite capacity, and those who are mentally incompetent for whatever reason, all right? So you have to have competency in order to have a valid contract. Minors, typically under the 18, you can't enter into a contract. You can have a guardian or parent sign on your behalf. Same thing with people who are mentally incompetent. You also got to think about people who are under the influence, right? Or do they have the capacity to enter into a contract? All right, minors and those who don't have minors or those who are mentally incompetent. Is interesting. They can enter into a contract, but they can be disaffirmed at any time. All right, a little bit different than the other elements. A contract still may be valid for a while until it is disaffirmed. All right, a little bit different, but it is a necessary component to every contract. The next thing I want to talk about real quick are oral contracts. Are oral contracts valid? Yes, oral contracts are valid. Generally speaking, an oral contract is enforceable under the law. The problem with them is they're hard to prove. All right, they're hard to establish the terms. So when you get to court, well, I had an oral contract. Well, how do you prove that? There are ways to prove it, right? There are ways to prove it. If we were taking a sports law class, we'd be going through that right now. But for our purposes, generally speaking, oral contracts are enforceable. Tough to establish the terms, but they are enforceable. There are certain instances though, where oral contracts are not valid. All right, those are times when you agree to buy land, which probably isn't important for us in the NIL world. Our contract for goods over $500 in some states. So if you're buying something over $500 in value, that needs to be written down. It can't be oral. As in some states, though, not every state. And if the contract cannot be performed within 1 year. So if you're employed for a 3-year contract, well, then that needs to be written down. Right, that needs to be a written contract. It can't be an oral contract in order for it to be valid. So if you sign a three-year deal with Nike to do their endorsements, well, that needs to be reduced to writing. Okay? All right. Some contract provisions you need to think about when you're entering into an NIL deal. Who the parties are, right? Student athlete and the party who wants their services, right? That's typically who the party is, and that could be the brand, an autograph signing company, summer camp, whatever it is. But those typically are the parties, right? The student athlete and whoever else wants their services, and that could be a variety of entities. So one provision is parties. Another is the duration or term. I like to say term. Do not, in any contract, leave the term open-ended. Right? No indefinite contracts. It's a contract for a year. It's a contract for 6 months. It's a contract for 3 years. But do not say, well, until we don't want to be associated anymore. No. No indefinite terms in a contract, right? Figure out that time frame. Could be 6 months, a year, 3 years, whatever it is. But make sure that duration or term is part of the contract. The next element or next provision is termination. How are we going to get out of this deal if we're not happy? One party's not happy, right? How a contract can be terminated or ended. All right, you need a contract. You need this clause in a contract. It could be by mutual agreement. Both parties can say yes, we mutually agree to terminate this contract. Then that's fine. Could be for a reason, for a cause. Somebody did something. Somebody breached the contract somehow. Right? They did something that was outside or against what the intent of the contract was supposed to be. Most of the time you have to give written notice. In that circumstance, so that person can kind of make good. But it depends on the language itself. And a lot of times within a contract can be terminated due to a morals clause. Right? Due to a morals clause. Somebody does something unethical, or they do something that embarrasses the brand, or they do something that embarrasses the school. Right? Then that could be a reason to terminate the contract. Okay, but make sure the determination clauses are pretty well spelled out. Okay, that's important. And with that goes a buyout clause. Allows a party to determine how and when the other party can buy out or be bought out of the contract for whatever reason. Right? Parties just don't want to move forward with this company anymore, right? They're getting a better deal with Under Armour, right? So I want to buy out of this contract. I don't want to be stuck in here for 3 years. How can I buy out of it so I can move to that better deal? Okay, make sure that's spelled out within those terms. Compensation, really important, right? How you're going to be compensated. How the student athlete is going to be compensated for their name, image, and likeness. And this could be in the form of money or product, right? But you want to make sure that the amount is specifically spelled out, when it's going to be paid, the frequency of payments, who will be paying, and who will be paying, right? Who's going to be paying me, how they're going to pay me, when are they going to pay me. All this needs to be figured out within that contract. All right, you don't want to. I did a contract one time where an athlete had to come to camp at 300 pounds or less. Right, the first he used to get. He used to, yeah. He's in the off season. He put on a few pounds. So the deal was, we came to camp 300 pounds or less. He got $100,000. He got a $100,000 bonus. But I made sure in that contract that it was paid by the end of the day. Okay, because the team came to me and they said, okay, we'll pay you at the end of the season. I'm like, no. Term says he walks out of here with the check today, $100,000 today. Okay, so make sure it's in the contract itself. All right, the scope of services. All right, what are you doing? All right, what are the parties receiving in exchange for the compensation? Are you doing public appearances? How many? How frequently? Are you doing postings? How many? How frequently? Meaning all of this needs to be spelled out within the terms of the contract. I put a couple contract. I think I put an endorsement contract up on Canvas. Take a look at it, right? Because it kind of spells out what the scope of services are. And who's going to own the intellectual property? What is authorized to use, and who owns it? Those are two important things. Can you make sure that you can use the brand's IP in whatever you're posting? Make sure it's clearly written out that I can use the brand's intellectual property in my online postings, in my reels, in my LinkedIn pushes, those kind of things. All right, make sure that you can use their IP. For how long, and then who is responsible if something is created? Who owns it and who is responsible for protecting it? Those are two very important items. So if the new intellectual property is created during your relationship, who owns that IP and who's responsible for protecting it? All right. And what if there's a breach? What can happen? Just thoughts. All right. No non-compete clauses are very important. Parties agree not to compete with each other in certain places during certain periods of time and in the same industry. With non-compete clauses, you really need to look to the states for guidance, all right? Because a lot of states have different laws on what can be included and not be included in non-compete clauses. How long, durations, those kind of things, all right? So generally, there's going to be a non-compete clause in your contract. Just look to the state for guidance on how that needs to be set up. Next item you need to think about is jurisdiction. What state or country, so be it, has jurisdiction over the agreement? Is it the state of the student athlete? Is it the state of the brand or company? But that needs to be clearly spelled out within the contract itself. All right. So we're in New York. Jurisdiction should be New York. That's what you'd want, right? You got that home field advantage. But if you're dealing with Under Armour, they're down in Maryland. They may say jurisdiction is Maryland, or Nike may say Oregon, or something like that. But we're in New York. We could say the jurisdiction should be in New York because I don't want to fly out to Oregon if there's a breach and have to litigate this matter out there. Okay? And then dispute resolution. Should you use courts or should you use arbitration? All right, a lot of times there's a dispute resolution clause within your contract. In the contract I put up on Canvas, there is one. And it basically says you need to go to arbitration first to try to resolve your differences. And there it gets interesting because whether the arbitration is mandatory or not and whether it is binding or not. All right, whether the results of the arbitration are binding and you can't go to court. All right, so the terms really need to be looked at. Can you go to court? Do you need to go to arbitration first? And then if you go to arbitration first, is that arbitration award binding on the parties? Or can they say no to the arbiter and then go to court? All right. And the last thing, read the contract. Always read the contract. I'm going to say it again. Read the contract. One more time. Yes, read the contract. Read it. Understand it. If you don't understand something, ask questions. If you don't feel you're getting a significant answer, call me. I will go over the contract with you. I can't, but I'm just saying, call somebody who has experience with contracts. Have whatever, read it to them, tell them, give them a copy of it, let them know, well, what the contract says, because you don't want to be left going, I didn't understand, or I didn't realize that was the contract. I didn't understand I was supposed to do that. I didn't understand I was only going to get paid this much. No. Read the contract, and have somebody else, if need be, look over that contract for you. Okay? Fair enough? All right. Any questions, comments, criticisms, please always feel free to call me, contact me on Instagram, email me, text me, whatever it is. Okay? Hope this was helpful. Take care. That's me. Thank you.